Mr. Chief Justice, and may it please the Court. My name is Monica Haddad, and I, along with my co-counsel, Alex Lambach, represent the Respondent, the United States, in the appeal before this Court. The government respectfully requests that this Court affirm on de novo review the judgment of the 14th Circuit because it correctly interpreted the plain meaning of negligently in the context of 1319 C1A of the Clean Water Act to be a civil standard of negligence, and also corruptly persuades in the witness tampering statute, section 1512b3, means motivated by an improper purpose. I will be addressing the Clean Water Act, and my co-counsel will address witness tampering. The 14th Circuit interpretation of negligently was correct, since it was consistent with well-established principles of statutory interpretation set out by this Court. Additionally, since the Clean Water Act is a public welfare statute, a lower mens rea is appropriate in this context to convict.
But counsel, the Fifth Circuit said that it's not a public welfare statute in United States versus Ahmad. So what did the Fifth Circuit conclude that you would suggest to us is wrong?
Your Honor, United States versus Ahmad, the Fifth Circuit actually looked at section C2, which has a knowingly mens rea, and was concerned with criminalizing otherwise lawful conduct if someone didn't have that knowing intent, knowing they were actually discharging a pollutant. In that case, the defendant was emptying his gasoline tank at his gas station, emptying many gallons of what he thought was water, but it was actually gasoline. And in that case, the court was concerned with convicting someone for a high felony penalty, which knowingly does carry, I believe, up to 3 years. Whereas here, C1A, a negligent mens rea, only includes a fine and a penalty of up to 1 year imprisonment. Instead, this court should look to Hanasek, United States versus Hanasek, where the Ninth Circuit stated that section C1A is public welfare statute and upheld the defendant's conviction in that case, where he was, just like in this case, like Mr. Millstone, a supervisor of an employee who was negligent on the job and caused a spill. And in this case, we have evidence on the record of the indications and the consequences of someone being negligent.
Well, counsel, is it your argument that when we deal with the knowing provision of the Clean Water Act, that the Clean Water Act is not a public welfare statute, but when we look to the negligent provision, then we say it is?
Your Honor, the government believes that it is all public welfare statute. The goal of public welfare statutes is to protect society. As petitioner mentioned, this is overreaching by the government. In this case, the overreaching protects society, and that is the nature of a public welfare offense, where we are willing to penalize that one individual, although he may be ignorant of the law, ignorant of the consequences, in the interest of protecting, and in this case, the American waterways. It is worth convicting.
But counsel, any simple negligent act could cause an individual to lose 1 year of his or her individual liberty, correct?
Yes, Your Honor, that's correct.
And yet you say that you can do that because of what? Why is that consistent with due process and fairness? A simple negligent act.
Your Honor, the goal in this case, as outlined by this court in Staples versus United States, the criteria for a public welfare offense is that there is some regulation of a potentially harmful or injurious item. In this court's decision in International Minerals, obnoxious waste materials were also added to that list, and in that case we had sulfuric acids. This, again, is just like those types of the dangerous chemical is also would fit in this category. Additionally, a reasonable person would be on notice of the regulation. Mr. Millstone knew he was securing a large chemical plant. He should have taken more steps to prepare for that extremely large job that he was not accustomed to completing. And additionally, this is a light penalty and no harm to reputation, because as this court stated in United States versus Freed, up to 1 year imprisonment is acceptable under the public welfare
Counselor, how can you possibly say this is a light penalty and no harm to reputation? I mean, surely if you're sent to jail over your negligence involving this tremendously high-profile environmental disaster, I mean, that's going to be a significant harm to reputation.
Well, Your Honor, the harm to society and to this community was extremely severe, and to just weigh the costs of punishing this one person who did have a responsible relation to the act that caused the spill, it is worth punishing that person. And in the scope of things, 1 year imprisonment really isn't that bad when you consider 23 people have died and $1.25 billion worth of loss is indicated on page 8 of the record. Furthermore, going back to the statutory interpretation...
Counselor, what exactly did he do that warrants 1 year in prison?
Your Honor, it would be up to the court to decide exactly what kind of imprisonment he would get, but in this case, the jury found that he was negligent.
Well, Counselor, don't we have sentencing guidelines?
Yes, Your Honor.
Aren't I obligated to follow them?
They're only advisory at this point.
Okay.
Your Honor, but the fact is that there is prosecutorial discretion built into the Clean Water Act, specifically into C1A. In this case, Congress has provided different levels of mens rea. There is a negligence standard, there's a knowingly, and then there's the knowing endangerment.
Counsel, there's no prosecutorial discretion built into the Clean Water Act, is there?
In which charges to press, Your Honor?
Sure. I mean, in the Clean Water Act itself, there's no prosecutorial discretion.
But as a prosecutor would be able to choose, Your Honor, which charges to pursue. And negligence, it has been argued that was inserted.
Well, Counselor, opposing counsel made a fairly good point on that it's not something for us to rest our hat on, that prosecutors will make the right decision and not prosecute something. And due process doesn't work that way, does it?
No, Your Honor, it is to protect the interests of individuals. However, in this case, there is a mens rea in the statute. It's not a strict liability statute. The court below, they were able to prove that Mr. Millstone's actions were negligent in this
Counselor,
case.
I'm very concerned, though, with the effect this has on anybody who wants to enter into any sort of business that involves, I wouldn't even have imagined before this case that, a security company, employee could end up going to prison over a violation of the Clean Water Act. What if we just look at sort of this standard negligence? Aren't we making it basically impossible to control for all the things that might lead to criminal liability?
Your Honor, it would be just another hazard of entering into a particular business, choosing to accept that security contract. Again, just accommodating for the risk and planning ahead.
Counselor, I think there's a fundamental problem here because almost all water at some point ends up into a waterway that's going to be regulated. In the Fifth Circuit case, he didn't turn around and dump it into the ocean. He poured it into a sewer that led to a waterway. In this city, there's bayous that drain all the water into public right-of-ways that are tied into all the sewage systems. So everybody is in effect subject to go to prison for 1 year if they're found simply negligent.
Yes, Your Honor, but that's exactly what Congress intended. And in looking to the broader context and evolution of the statute, Congress has had multiple opportunities to go back and change the statute and accommodate for that, but has again looked back to the public welfare nature of the statute to protect society as a whole.
But how do you respond to the argument that in fact that's not what they intended because this was done in the context of criminal liability and not civil, and therefore that brings with it more than just simple negligence?
Your Honor, Congress is presumed to know of the terms it adopts when it drafts legislation, as this court stated in Rosello. However, what happens is, again, if you look to Section 1321, I think it's B7D, another provision which allows for prosecution, there is a gross negligence standard that was enacted after. Congress is presumed to know the language. It has shown that it can indicate different grades of culpability, and in this case, the short answer is that Congress did not write the statute that way. This court should look to the plain meaning, look to the standard definition of negligence, where Congress adopts particular terms that have well-established common law meanings. It accepts all the ideas that go along with it. And looking to the broader context, and even the legislative history, in this case, if the court were persuaded by petitioner's argument, the statement of Representative Harsha in 1972 stated, and I quote, "We can already charge a man for simple negligence. We can charge him with a criminal violation under this bill for simple negligence." All the way back in 1972, when the criminal penalties were first added, Congress acknowledged that they intended simple negligence as the standard for this court to use.
So, counsel, maybe getting back to the question I asked earlier, based upon what you just argued, is it your position, if we were to square what happened in the Fifth Circuit with what happened here in the 14th Circuit, that if we have a portion of the Clean Water Act that deals with a knowing violation, that would not necessarily mean that that was a public welfare statute, because it has some scienter or some knowing requirement to it. But when we go to the negligence standard, there's no knowing requirement, there's no scienter requirement, so then it has to be public welfare. So it's kind of a schizophrenic statute, so to speak.
Yes, Your Honor.
Is that your argument?
It is confusing, however, it just provides an alternative if this court is not persuaded that negligence is the correct ordinary civil standard of negligence, the failure to exercise due care. This fact that this statute is a public welfare allows for a lower mens rea in any event or strict liability. Here, petitioner makes much of the fact that this is such a low mens rea. However, it is better than nothing in this case, as we have seen people be convicted for ordinary negligence in the past, as in United States versus Ballant, and also United States versus Freed, where the possession of a hand grenade was also just a strict liability offense. But the fact that it was a public welfare statute allowed for this somewhat seeming harsh penalty in that case.
What if we conclude that this is not a public welfare statute? Do you lose?
No, Your Honor, because if based on the plain meaning of the term negligence in the statute, and it would have to be remanded if for some reason this court adopted a higher standard, but based on the jury finding below, Mr. Millstone's actions were found to be negligent.
So you would lose. We would have to remand for another trial, for another court to determine whether or not this then had a heightened requirement, such as gross negligence, criminal negligence, something knowing violation. But you couldn't win this case if we were to conclude that this is not a public welfare statute. Do you agree with me?
I'm not sure if I follow, Your Honor.
Well, if we conclude this is not a public welfare statute, like a mod, then you can't win before this court on this issue.
Based on the negligence, we still could, since it already has been, unless this court were also to abandon the negligence standard, the plain meaning.
Well, counsel, didn't they find in the lower court that he was guilty of simple negligence and not criminal negligence?
Yes, sir.
So I think my co-justice question is when we then have to remand because he hasn't actually been tried under the plain meaning of criminal negligence.
But the plain meaning is the simple standard of negligence, Your Honor.
Isn't criminal negligence the civil equivalent of gross negligence? There has to be a level of maliciousness to it.
Your Honor, but looking to civil and criminal provisions, it would just have to be what is the plain meaning there. And in this case, we only have negligence. So it would be up to this court to go ahead and rule that it should be gross negligence. And the court is always reluctant to put words in Congress's mouth where they have not chosen a particular language in the statute.
So there is, under your argument, no difference between criminal negligence and civil negligence.
There is a difference, Your Honor. However, in this case, Congress knew that they were enacting a provision of the criminal penalty section of the Clean Water Act. And they still
used just the word negligence.
Yes.
So shouldn't we assume they meant criminal negligence and not civil negligence?
No, Your Honor.
Criminal statute?
No, Your Honor. It is the plain meaning. Based on well-established principles of statutory interpretation, we use the words that are there. And in this case, we have negligently. And looking to the plain meaning, looking to the broader context of the statute, the fact that Congress used different levels of mens rea throughout the Clean Water Act, and the legislative history, a quote from a representative who was part of the negotiations and the enactment of this penalty, we see here that it is simple negligence. So this court should uphold the decision of the 14th Circuit and hold that negligently, as it was interpreted by the 14th Circuit, is the correct manner. Additionally, the rule of lenity would not apply in this case, since we do have the plain meaning interpretation and also the public welfare statute. There's no ambiguity and no need, since the petitioner's due process rights have been protected.
But doesn't that get back to my prior question? That is, we have to conclude two things for you to prevail. One, we have to conclude that this is a public welfare statute. And two, based upon it being a public welfare statute, we could then say ordinary negligence is sufficient. But you can't have the second without the first, can you? Doesn't it have to first be a public welfare statute for us to say that it would be okay to then criminalize simple negligence?
Your Honor, this court has already upheld other statutes which use the simple negligence standard. So either one would be sufficient in this case. Based on just the negligence standard, that is sufficient mens rea to convict criminally. It's been upheld in many other cases. Additionally, another enforcement for the government's position is that it is a public welfare statute, which only reinforces the fact that we have the negligence standard in this case. And for these reasons, the respondent respectfully requests that we affirm the decision of the 14th Circuit.
Thank you, counsel.
Thank you.
We will now hear